Bonjour tout le monde, mesdames, messieurs, ladies and gentlemen, good, it's not quite afternoon yet, so good morning still. Mon nom est Nicolas Vermeil, je suis le directeur du Centre de recherche en droit public et au nom de ma collègue René Claude et moi-même, nous sommes bien heureux de vous accueillir à ce midi-conférence co-organisée par la faculté de droit et le Centre de recherche en droit public autour de la thématique de l'artificial intelligence, oui, je vois le titre en anglais, l'intelligence artificielle appliquée au droit. So for those of you who are joining us who do not speak French, I just said my name is Nicolas Vermeil, and it's my pleasure to welcome you to this lunch conference on artificial intelligence applied to law, co-organized by the CRDP and the University of Montreal Faculty of Law. We have a pleasure to have had within our walls for the past few months now, and still for a while, two brilliant researchers from Brazil. The first one, and I will be a gentleman and not follow the order of the bios here, but start with Debora Bonat, who is an adjunct professor at the University of Brasilia's Faculty of Law. She has been a counsel for the president of the Federal Tribunal of Brazil, and she was a co-leader of a group. She is the co-leader of a group called DR.IA, which is law, argumentation, and artificial intelligence. And sitting next to her is, I now can officially say my friend and colleague. We met a few months ago and have enjoyed each other's company. Fabiano Hartmann. Fabiano is also a professor of law at the University of Brasilia, and he is a lead researcher at DR.IA. He is the author of numerous books on law and artificial intelligence, and it is my pleasure and honor to welcome both of you and to cede you the floor. We have roughly 40 people that are joining us online, as well as the people in the room. You can stay at the table if you wish to, or you can come up to the podium as you see fit. So I will cede you the floor, and thank you once again for accepting this invitation.
Thank you so much.
Thank you so much.
Thank you.
Good morning, everyone. Bonjour, tout le monde. J'ai désolé pour ne parler français aujourd'hui. I am Professor Debora Bonat from University of Brasilia, and he's Professor Fabiano Hartmann. We are professors and research in the research group in Brazil, the DR.IA, about intelligence artificial and judiciary, Brazilian judiciary. Today, I will briefly discuss our collaborative research and development experience, primarily with the Brazilian judiciary and the impacts of the justice system in Brazil. To do this, we propose to discuss the following items. Our background, the Brazilian judiciary, the ethical standards, logistics concepts used in our laboratory, and AI projects. We have many projects in AI in Brazil with the judiciary power and the attorney publics in Brazil. The AIs are Victor, Mandamos, Osiris, Ale, Sabia, and Pedro. Okay, this name is Brazilian names. Is our university in Brasilia, the capital federal in Brazil. Brasilia began its activities in 1962. It's a very younger university, with the promise to reinvent the higher education in Brazil. The university was conceived by the anthropologist Darcy Ribeiro and educator Anísio Teixeira. The architect Oscar Niemeyer turned their ideas in buildings. This is an airplane. The city, Brasilia, is in a building in format airplane too. Today, the university has 4 campuses, 132 undergraduate programs, 93 master programs, and 78 doctoral programs. In the law school, we have 72 professors and 2,708 students. In addition, our postgraduate program in law was received the prestigious designation of being of program excellence in Brazil. We have in Brazil an agency denominated CAPES, and the CAPES regulate the activities in the postgraduation in Brazil. Our program is one of the largest postgraduate law programs in the country, with 50 professors, and the most of them are dedicated exclusively to research. This is our laboratory. Our laboratory is DR.IA, in English AI, is integrated by a multidisciplinary team composed by lawyers, philosophers, computer scientists, and undergraduate and graduate students, master degree and doctoral degree in Brazil, and postdoctoral internship. Today, we are 52 members, 8 PhD students, 6 doctoral students, 12 master students, 2 LLM students, 19 law students. In addition, we have 4 postdoc internship researchers. In addition, the lab is structured in these following lines of research: artificial intelligence and law, judicial procedure and artificial intelligence, analysis and evaluation of legal reason, rationality in legal discourse. The DR.AI, our group, maintains a dialogue with the National Council of Justice in Brazil and with the Brazilian Judges Association. The main activities of DR.AI are discussion of scientific topics and tests, organization and participation in scientific events, production of papers, books, and the other materials for academic publications, and execution and applied research projects. This, the Conselho Nacional de Justiça in Portuguese is National Council of Justice, is the major regulator organ in Brazil about the justice, okay? A significant partner of DR.IA is the Brazilian judiciary. Brazilian judiciary is chaotic, okay? It's incredible. The laboratory partnership with the Brazilian judiciary arose from the necessity beginning in the face of a chaotic scenario of lawsuits. Just to give you an idea today, the Brazilian judiciary can be seen through a few numbers, okay? The annual expense in Brazil, it is at 1.5% gross domestic product. Is very expensive, very expensive. But I have a stock of case, almost 81 million today in Brazil. Annual new cases, almost 31 million, okay? And the duration of the judicial procedures, the lawsuits, 10 years, 10 years, okay? Faced with this catastrophic scenario of 81 million lawsuits for 211 million people, the first step was to seek a change in the procedures for appeals to reach and the higher courts in Brazil, okay? This is judicial power in Brazil. We have many judges, civil judges, criminal judges, electoral judges, military judges, okay? There are many judges in labor judges in Brazil. And we have 2 high courts in Brazil. We have the Superior Court of Justice. Superior Court is the bigger than high courts, and we have the Supreme Federal Court, okay? It's a constitutional court in Brazil. Brazil has 11 judges in the Supreme Court, which the rules on constitutional matters, and 33 judge Superior Court. which rules on matters of federal law applicable everyone in Brazil, okay? The High Court, Superior Court of Justice decide and everyone gets the decision. The Supreme Federal Court has almost 24,000 cases in stock. Meanwhile, the Superior Court of Justice has almost 312,000 cases in progress. In order to speed up the processing of cases and to try to reduce the changes of cases reaching the high courts, Brazil has implemented a policy of legal precedents. However, due to our unique circumstances, the judicial process in Brazil works differently than in the rest of the world. Okay, of course. The legal process begins with the single judge and, upon appeal, reach the high court. In order of the appeal to be accepted by the court, the party must demonstrate that the matter has economic, legal, or political significance for the judge to decide the case. In this case of the Superior Court of Justice, it's necessary to demonstrate too many similar cases for the case to be considered. When an appeal reaches the high courts, the first step of the high courts is to check if another same case has already been decided, okay? If it has, the appeal is returned and the previous decision is applied for everyone. If the subject has not been considered by the court, the judge orders the suspension of related cases in Brazil until the high court makes the decision, okay? So instead of the court deciding 1,000 cases, it decides only one, okay? The problem is that we currently have almost 18 million cases frozen in Brazil, awaiting a future judicial decision for 5 years, 10 years, and one case, 13 years frozen. Yeah, it's crazy. When the court rules on a case, it formulates a thesis that summarizes the decision, and these theses become mandatory for all judges. This means that all judges in Brazil are required to follow the decisions of the high courts. Okay, but the thesis, this is one thesis, okay? This is 15. This is an example of what judges should follow. It's worth noting that in the system, judges and lawyers don't have to look for the reasons behind the decision, but should focus only on the thesis. This is a new rule in Brazil. The Supreme Court and the Superior Court in Brazil make every day new rules, okay? To date, the Federal Supreme Court has more than 1,000 theses, while the Superior Court of Justice has more than 900 theses. The first IA in Brazil, named Victor, emerged in this context, and it was this time that our laboratory began to develop AI solutions for the Brazil judiciary.
First of all, I would like to thank you for CRDP and thank you for the University of Montreal for this warm reception and for this opportunity. We have already discussed the presentation of our university in Brazil, our lab, our dedication to AI research in the courts of justice, and the Brazilian judiciary, the higher courts, and the concept, the different concept of precedents in Brazil. A little bit different from the traditional concept of precedents. There are many ways to develop and use artificial intelligence in the context of law. There are also many impacts on legal theory, public law, like credit recovery, public purchase, provision of public service, etc. And private law too, legal personality, contracts, civil liability, intellectual property, etc. Among the many paths of research, we have chosen to focus on our research. Develop concepts for ethical robustness in AI, and two, the development of applied research related to the realization of fundamental rights. My speech will begin with some of these aspects, and then we talk about the R&D projects like Vitor, like Mandamus, like Osiris, Ale, Sabia, and the last one, Pedro. I would like to introduce our ethical standards. Okay. In the context of research and innovation, in an environment without sufficient regulation, we need a more specifically ethical framework for our pioneer AI Victor project in 2018. AI Victor was the first AI in the Brazilian judiciary and resulted from a partnership between the Brazilian Federal Supreme Court and the University of Brasilia, with funding of approximately $700,000. We have needed ethical standards for the formation of the research team, for the process of data extraction, treatment, cleaning, and the formation of training and testing datasets. Also, we needed ethical standards to guide research hypotheses. Our choice was a logic of support, of assistance, and not the substitution of the human beings. Our solution also designed for a collaborative and cooperative environment. We needed, at the time, a virtual environment for providing AI solutions accessible to the courts and maintained by the National Council of Justice. So, in 2018, I wrote a book based on international experience, including the CyberJust one, outlining 14 standards for a robust legal AI solution. That's listed in the projection. Of these aspects, due to time, I would like to highlight one aspect of the substantial representation principle, which is a gender representation. Our lab has gender parity for its leaderships to all of research teams. So we have either more female participants or at least equal representation, including in all times work leadership. Our academic events are the same way. AI Vitor was trained by experts, jurists, most of all women. I think that AI Victor was a female brain. The name Victor was given by the justice of the Brazilian Supreme Court in honor to a former justice, Victor Nunes Leal. But the brain of the Victor, it's a female brain. Our ethical standards were developed within the concept of maximum relevance in the dataset curation process. The formation of dataset is a central element in the ethical robustness control of AI solution, and the participation of law experts with knowledge of the data always be essential. So, legal data experts participate in the entire development cycle of the research project, from defining the legal documents for the dataset formation, extract, transform, and load, ETL, exploratory analysis, modeling exercise, and finally define the front end and the transferring technology to the judiciary. Shortly, I would like to discuss the logistic concepts that we have developed to our AI solutions. The idea is always to develop AI as a support for human activities to reduce what we consider the correct times in the maturation of the judicial process. The AI mandamus is a best example of applying the concept because it addresses to issue of delay and difficulty in acts by court bailiffs. Logistic aims to improve human efficiency. Logistic is not aims to replace human activities. Our logistic standards in the Osiris project, which classify judges' decisions and associate them with templates for integrate petitions attached to the database for searching new address and location, real estate investments, bank deposits, including crypto assets obtained from broken companies. In Brazil, there is a great difficulty in finding tax debtors, and often the so-called prescription of debt collective actions happen if a debt to the state is not paid with 5 years. The difficulty is recovering debts reduce the state ability to finance important public policies, among other things. Now, let's talk about the AI projects. Okay. Victor is an AI solution that was developed between 2018 and 2021 through a partnership between the Brazilian Federal Supreme Court and the University of Brasilia. I had the honor of being the head of this project. Victor made the beginning of AI era in Brazilian judiciary. Victor was responsible to the chaotic state, like Professor Bonat told us, of judicial process in Brazil. Here are some examples. There were approximately 80 million active judicial cases in the country, with a population about 215,000 million people. Deadlines for lawyers are fixed and must be observed. However, the judiciary deadlines are not performed. On average, a judicial process lasts around 10 years. In 2018, the Brazilian Federal Supreme Court received approximately 400 new cases per business day, and it's mandatory for the court to present a decision. In 2018, there was a strategic plan for the court to achieve an average trial time of 1 year. The primary filter establishment for the court judgments is called general repercussion. Is it determined by economic, social, legal, or political relevance, with more than 1,000 theses. Analysis by the human beings of new cases for teams classification in 2018 have an average time of 70 days, more than 2 months. The court received an electronic native or scanned judicial process with manual indexing of relevant procedural documents within the PDF and unstructured data with many variation of PDF standards. Let's talk about the hypothesis from the AI Victor. Are the legal data from the Brazilian Supreme Court suitable for the application of any machine learning technique? The answer primary is no, because a primary authorization solution was necessary. It was also necessary to develop a document classifier to identify pieces of interest into the PDFs, such as extraordinary judicial appeal, grounds to extraordinary appeal, and counter arguments to extraordinary appeal. The second one, the hypothesis. Can any machine learning technique be applied to identify patterns in the legal test? The answer is yes. Classifier algorithms were used based on labeling done by legal experts. And the last hypothesis. Is it possible to apply a solution to classify all themes? The answer is no. First, we select 26 themes, but that means almost 30% of the stock of the case. Victor architecture was designed for two main challenges: identify the piece used by human clerks within a case to classify a new case under general repercussion team, and two, training a theme classification model for general repercussion. What was the performance of the Victor? Reduce the average time for classifying case to 4 seconds, the 7 days to 4 seconds. Increase accuracy, as about 25 of human-made classification received revision by the judges of the court, because of course, it was a complex legal test. Victor was an accuracy rate of nearly 8%, better than human. And what F1 score in TEMS classification average above 0.9% in many TEMS. Beyond technical indicators, what's also important to note, AI Victor marked the start of culture of applying AI in the Brazilian judiciary. AI Victor ensured a focus on support rather than replacement of human elements. And more, AI Victor ensured ethical consideration and regulation in the space of cooperation. But the challenge that remains in the restriction of access to the judicial data for measuring transparency and monitoring the system of AI. Now let's talk about the AI Mandamus. First of all, let's discuss the context of development of Mandamus. Mandamus is an AI solution developed in 2021 through a partnership between the Roraima State Court and the University of Brasilia. I also had the honor to be the general coordinator. The project was entirely developed remotely because COVID-19 times, without personal contact among researchers, which allowed us to redefine our R&D methodology in this regard. Some relevant numbers for Mandamus. The average time for the action to be supported by AI was 45 days. 45 days to execute a judicial warrant. This is the target of Mandamus. There was more than 50% rework associated with this action. The court was beginning its transition to electronic case management. What's this hypothesis of AI Mandamus? First, it's possible, based on available judicial data, to generate a machine learning classifier for judge's decision to lead to a judicial warrant. The second hypothesis, can a template be associated with key information to reduce that rework? The answer for both is yes. It's possible to create a classifier and associate it with an automation using templates for judicial warrants, resulting in an appropriate and complete document. And the third hypothesis for the Mandamus, is it possible to establish an order for judicial bailiff to optimize the execution of their tasks using machine learning? The answer is yes too. It's possible to do a balancing and create an update classification for each unit of time, indicating the best bailiff for execution the warrant. Mandamus architecture was designed for two main challenges. First of all, a classifier robot for judicial warrants. It reads the judicial decisions, classify them, and generate the respective warrant through templates. And the second AI solution, a distributor robot. It classifies bailiff every 10 minutes, balance some objective aspects, like the proximity of the address of the warrant execution with the bailiff by geolocalization. 2, the complex of warrants executed in the shift by the bailiff, and 3, the urgence of the warrant itself, matters of physical integrity, health, involving of vulnerable groups are prioritized. Performance of mandamus. For the architecture of the warrant generation, we used a Django REST and with a technology including fast AI and XGBoost. For the classifier of generate and doesn't not generate warrant, we active the following F1 scores. 2 special civil courts, 0.972 F1 score. 2 special criminal court, 0.995 F1 score. 2 civil court, 0.97 F1 score. 2 criminal court, 0.96 F1 score. Beyond these technical indicators, I like highlight some aspects. AI mandamus make the beginning of integration of AI solution in the judiciary from a central administrative board, the National Council of Justice. As a regulatory board, the Council also established the Resolution 332, in which I assist as a representative of Brazilian universities in regulating ethics and governance in AI for the judiciary. It was based on the principle of non-discrimination, transparency, predictability, auditability, impartiality, and judicial substantial justice. Sorry. The major innovate of this element was the restriction of the use of AI in criminal law matters. Since that day, Brazilians don't use AI to criminal matters in the judicial power. Let's talk about Osiris, Ale, and Sabia with Professor Bonat.
The AI Osiris. The Osiris is a name, the authority in Brazil, is an important authority in Brazil, and the name is our project. The project began in January 2022, okay, and we are made in this project now. And it has partners, including the Attorney General Office of the Federal District in Brasilia, the Foundation for Research Support in the Federal District in Brasilia too, and the Federal District Court of Justice in Brasilia too. This objective is to read documents from the judiciary and generate the corresponding draft to answer the judge's orders. Additionally, Osiris will be responsible for generating and managing a database for debtors' addresses. This is a problem in Brazil, so big problem. This is crucial because in 96% of the cases, they end up expiring due to the inability to locate the debtor to serve their notice. Osiris will utilize the classification system, and for this purpose, almost 13,000 documents have already been annotated today. It will have an immediate impact on 278,000 cases in Brazil. This is an amazing project. The LA project is 2 major fronts. The first is to develop an AI and innovation hub for the Federal District, and the second is the clustering cases from the federal justice system. Identify recurring situations that can lead to batch processing and identify likely scenarios for repetitive precedents. It's a project with 1 more year of execution, but the results are already kept satisfactory. It will have an immediate impact on more than 2 million cases in Brazil. And Sabia projects. Sabiá is a bird in Brazil. Sabiá is a project developed in partnership with the Superior Labor Court, and it has two main components. The first involves clustering to assist in the management of work and human research in judges' offices. The second component focuses on educating jurisprudence. In both cases, you use data processing specifically designed for legal data and then apply the sentence BERT large model, depending on the type of document. This project ended in the January 2024, in the next year, and we have the great numbers with the project for the labor court in Brazil.
Okay. Let's talk about Pedro.
I think Pedro is the best. Okay.
Pedro means precedent extraction and discovery platform. But the most important, Pedro, is the name of our son. But it's only a coincidence.
Yes, only coincidence.
A good coincidence. We divided AI Pedro research in 7 stages, with first beginning of detail of working plan and activities, at the last one being the transfer of technology and training for the technical and final use teams of the Council of the Justice. I will detail you the other 5 stages here. The number of frozen process, suspension of procedure till the judgment by the superior courts due to general repercussion or repetitive appeals in higher courts is 22% of all stock. In other words, 7.7 million cases. The increase since 2015 in the number of qualified precedents that must be followed by the entire national judiciary. Today, we're talking, there are more than 2,500 precedents. The thematic diversity applied to the first instance of justice is huge, which would benefit from the solution is an important issue. What's the hypothesis for AI, Pedro? Is it possible to retrieve decision papers, juridic tests, defined as qualified precedents in natural language? Is it possible to prioritize unsupervised learning, given our experience have always supervised learning based? Is it possible to create a modular framework to make the two less or more restrictive in terms of similarities, depending on the prevalence of certain types of data? This is important. This is important for customizable use of the courts. The answer for this hypothesis is yes. We are very happy about this. The architecture of design these answers is starting from the presentation of new petition in complex legal language. In the new case, an AI tool will identify qualified precedents. It's possible to modulate the level of similarity based on the court's more restrictive or expensive needs. And maybe the tool achieves a level of abstraction sufficient to recognize new decisions patterns. It's an unsupervised learning. The first stage. We did a systematic review. Initially, a systematic review was conducted. The first conclusion was the high degree of pioneer working in this type of retrieval, both in English or in Portuguese legal language. The second stage, ETL, about extraction, treatment, and cleaning of data, I would like to highlight some aspects because I think it's very important to the law studies. We defined with legal experts the piece of interest for training and testing. We defined judicial decision as the most extruder and qualitative element, initial petitions, and responses. We excluded many data types based on qualitative criteria. In other words, for the critical potential biases. For example, precatory and specialized justice case were completely excluded. Criminal and labor-related cases were excluded because there is in Brazil an unbalancing matter because the labor justice takes a vulnerable group. We performed many elements of Lab's data correction concept. I would like to talk more about this topic, but there is another specific later on the complex topic for robust legal AI. The next stage was the ROP optimizer architecture. We needed to train our model with initial petitions, but the highest quality piece for location qualified precedents is the judicial decision. So, as a strategy, we made a 10 bank, it's number 1. We labeled it judicial decision and used it supervision and learning to find precedents. Number 2, it was the first steps in the ROP optimizer. At the same time, we also applied on strategy to expand semi-automatic labeling using a regular expression regex after preprocessing called GPAN preprocessing. By clustering judicial decision in qualified precedent teams using metadata, we linked that and formed a database for similarities, the number 3. What is the solution architecture? The solution aimed to form similarities between initial petitions based on clustering created by the hot optimizer architecture. With your dataset and similarity indices above 70%, all indicators of qualified precedent terms were relevant to the case. It's number 4. That's amazing. It was tested by experts, and we are very proud of it. But this situation doesn't mean that the index of 70% of similarity is a justification for any cutting of the tool. It's just a standard for the data construction of this framework. As hot optimizer is a semi-automatic solution, the framework allows modulation of similarity for application in other data realities. It's number 5. Pode passar a próxima, por favor. And the last one, the modulation. The framework of solution flow that allows for a more or less restrictive adjustment for similarity of the tools. In different scenarios with some multiplicity of actions in particular theme, with potential details discussion, the tool may become more restrictive. That's increasing the likelihood that recommendation will align with details of the discussion. And that's the tool in function. A very clean front end for the judges, for benefits of the judges. We put the PDF of the petition. It's a large legal test. So the judge can attach this test. in Brazil, the lawyers write a long test.
Yeah.
Yeah. I don't know in Canada, but
Yeah,
same here. Yeah,
yeah.
we love right. It's a huge petition. One little button and aperta o pause, por favor. And the two indicate the term of the precedent with the index of similarity. In our experience, above 70% always be correct. But under 70, there are some correct, some dispensable. But the modulation system indicate for us that it's possible to modulate or for other realities of data. That's important of this tool.
Just a question, please. Is this data scanned or is it analyzed in another way?
Sorry?
Is it scanned by the machine or is it analyzed in another fashion?
No, it's taken from the PDF of the platform from the work of the judges. He tried it and put in this front end of the tool.
In Brazil, law suites is electronic suites. We don't use physical
process. No
papers, no more.
The judges work with two screens. With the process and with the tools.
And you use PDF and use HTML.
Yeah.
If I may, why get the artificial intelligence to consider the petition? And I'll explain to you why I'm thinking this. The petition can be extremely long and have a lot of irrelevant information, whereas a summary that the judge made in the decision of what is relevant to the petition will be a lot more focused. So would it not give a great efficiency to the system if we actually ignored the petition?
Yeah, but in reality of us, for the first stage judges, there are many teams that then demands them to actualization. This is a tool of support. It does a mandatory tool. It does.
When you say it looks at the petition, it looks at petitions in active cases or
An active case.
Oh, okay.
Yeah, it's a new petition. New petition.
Okay.
Start the case now. New petition. The judges put in the tool, and the tool indicate, oh, attention by the 10 town.
Okay. No,
Okay.
so then you don't have a choice.
Okay. Oh, and I'm sorry, I'm finishing. Beyond technical indicators, I would like to talk about only three aspects. I think AI Pedro became a milestone at the first AI development by a central judicial board. So federal judicial and state judicial are intimate vinculed with this central board. It's important to expand a culture of robustness use of artificial intelligence. AI Pedro also submit to another project of the lab called Confia Seal for the analysis and evaluation of ethical standards and trust in AI. We know that AI carry on benefits and risks always, and we always attention with ethical aspects. And last one, AI Pedro will be a subject of a study in 2024. School of Advanced Students, that lab research seek to establishment with the University of Brasilia, University of Florence, and I wish University of Montreal. It's important to us. That we would like to discuss here. We hope we can identify common interests And thank you very much for your attention.
Thank you.